Good afternoon. Welcome to the First District Court of Appeal. We have one case today. It is THG Rentals versus James C. Arnold, and it's 15-970. Counsel, are you ready? You may proceed.
Excuse me. You need to be aware that there's a cross appeal, and so I've reserved 3 minutes for my rebuttal on that.
Okay,
I just wanted to not shut us down at the end of his rebuttal.
thank you for reminding me.
Sorry.
May it please the court, I am George Kagan here, speaking on behalf of the employer, THG Rentals, and the carrier's Summit Claim Center. In deciding this appeal, the court is asked to determine, sequenced logically, 4 things. Starting with the cross appeal in that logical sequence, the point is that whether the EC forfeited the affirmative defense by ambiguity in a December 9th pretrial statement per an objection tucked within claimant's trial memorandum filed 48 hours before trial. Not a separate motion or a pleading, just a trial memorandum. Under a rule which gives us 10 days to amend if it is timely objected to or brought up in a normal fashion, which is parallel, by the way, to a similar rule regarding a safeguard for PFBs that are improvidently drafted, where you can't dismiss a PFB without giving a chance to amend. Part of the rule that claimant downplays when she argues by analogy, what's sauce for the goose is sass for the gander, which we accept because there is a 10-day amendment period. No case should be decided by this gotcha concept, but taking it even as it lays, it's a moot point where the claimant's attorney announced readiness to proceed at 449 and 500 in the record, the attorney who took over the trial. The discovery attorney, for lack of a better word, had numerous conversations with the defense counsel about this defense. It was the subject of most of the expert depositions.
So do we now know what the misrepresentations are that you have based your affirmative defense upon? How many are there, and what are they?
Well, the order can be focused on one specific one, but if you study the deposition, it is permeated with misrepresentations. But the most specific one, and the one that the judge crafted a special apologia for, and again, I'm only focusing on the one that is to an absolute certainty to answer your question, and that is, did you ever lift any of the bicycles and put them into your truck? No, sir, I did not.
Well, isn't that kind of the problem with the rule here, is that the rule requires specificity, the rule requires detail, and what you're saying is it's permeated with them. Let me give you one.
Well,
that makes it a little bit difficult as a due process matter to respond to, given this rule.
Well, this is really a just saying objection. This is not a motion to strike or a motion for clarification. Remember that December 9th, the pretrial is written. The defense puts down its misrepresentation defense. Let's say it's arguably inadequate, arguably unclear. Let's talk about what follows. There's such a thing as mootness. There's such a thing as sitting on one's known rights. And in this particular case, what followed was 2 months of inactivity. 2 months of inactivity. There's the pretrial. Now you're preparing for the trial. Are you going to say that claimant's counsel was oblivious to the process of defending this case until 48 hours before trial when the trial memorandum comes in? The trial memorandum is a reflection of everything that's happened and how it's going to unspool at trial. It's not a chance for the attorney to say, like a V8 commercial, oh, I could have had a specificity objection here, and not even create an objection. Just put it in the trial memorandum. It's not a motion. Clarify this. And if he did, there's a 10-day rule that allows us to.
And your position is that she put you on notice for the first time 2 days before trial, and there's this 10-day period
that's right, following 2 months of inactivity.
In the rule, and before that 10 days had run, the court had already ruled in your favor on the specificity issue.
Well, it was brought up at trial. At trial, the attorney says, I'm prepared to go on anyway, at page 449 and 500. So it's a moot point. It's a total gotcha. With no harm done. And then we claimed surprise. Our defense attorney said, I've had numerous interactions where it was specifically gone over with in the depositions of the experts and what have you, in the 2 months or the preceding period. And so it's hard to envision a more moot or waived point than this, where it sits fallow for 2 months of inactivity and then surprise, objection, not a motion, just a commentary in my pretrial memorandum, which describes how the case goes. It's not a time for new offensive pleadings that have the opportunity to derail litigation. That's not how litigation is done. What more classic gotcha can you have here? What it is a party admission by conduct that they were completely aware of what was happening in this case, prepared to encounter it, saying so on the record in so many terms, and stripping us of our 10-day grace period to amend. What sort of enactment of a rule for clarification is
So
that?
what if we agree with you on issue 1, but we think on issue 3 that's more specificity, that there's merit in that point, that there should have been more specificity? I understand that you weren't given the time you weren't given your 10 days. How would you advise us to send it back?
Well, you could remand it, except for a few things. The claimants, the employer suspended benefits on the basis of misrepresentation, and this was essentially locked in a time capsule at that point. When the misrepresentation was made, that was the claim. Now, you have an attempt to sever in this case, which is most unusual and unique, and the judge attempted to sever it by saying that misrepresentation sank to the bottom of the sea with claimants' withdrawn back claim. So we're here just on the leg claim. So the point is the judge, first of all, had no power to excuse the misrepresentation, which is what he effectively did with flourish of rhetoric. He issued an apologia. Well, I believe the claimant when he said he lifted that thing carefully. Well, that's not what the claimant said. I did not do that lifting. That was my wife. That was the seller of the bicycles, mostly the seller, but my wife. And no, sir. And that lifting was 2 weeks before the deposition. The questioning was encompassing a year. But the lifting incident was 2 weeks before the deposition. No, sir, I did not. So we can come back a year from now, but the end result is a foregone conclusion. It is the same, Your Honor, as if, the idea is that if they eliminate the petition, we're helpless. We cannot effectuate that misrepresentation. That's so fallacious. First of all, it's a doctrine that's repudiated in a couple of the cases we cited in the brief, but even more so, suppose, to give you the best example to graphically demonstrate why nothing can happen after this point that's good for the claim. If the claimant, let us say hypothetically, completely fabricated a notice of injury, the very first thing that opens the door to the workers' compensation world, the notice of injury, and the employer says, wait a second, that was a weekend accident. We have proof that he had that injury on Sunday and comes limping in on Monday. All right? And so they deny it from the start. Well, taking claimant's argument to its logical conclusion, not an extreme, but a logical conclusion, the EC would have to pay benefits and be powerless because no PFB was brought on that issue. That is absurd. What the carrier can do is controvert immediately, and if the claimant is feeling lucky, the claimant can file a PFB, which is how to effectuate unanswered requests for benefits. And the PFB carries with it a full litany of trial availability, discovery, the Judge CC, and then fees, sanctions in the form of penalties, interest. That's how the claimant is made whole. But should the claimant say, well, they got me on that one, the claimant will never emerge. That denial will stand, and that's the end of it. So the denial is the administrative answer, and the remedy is PFB. So the idea of, I threw that petition away, it's out of play, is a nullity. And so you have the petition is in play. The misrepresentations on top of it, it's entirely moot because the claimant makes it seem as though there's an impermeable membrane separating the representations he made concerning his inability to walk at all, sometimes 50 to 100 feet, but then he would say at all, without the assistance of his wife at his arm or a chair rail along a wall or his prop, as I call it, the scooter that he bought for himself, not one that's been prescribed by any physician, or the walker that he borrowed from a neighbor. These are props he assembled for this presentation where he's always proclaimed himself permanently totally disabled to anyone who will ask, early and often in the case. And so these representations were equally made to Dr. Pagano, to Dr. Salmon, to Dr. Smith, even in the small supplemental record. So you could not have bifurcated or severed the petition that was withdrawn.
Well, as I remember, some of the doctors were back doctors, and they were sort of out of the case early. The knee issue didn't arise for
Yeah, it's a
for
bit of
many,
a-
many months, and the back doctors, at least one of them might have been, or the back doctor might have been out of the way by then.
Well, that's true, but then they were brought in and they were asked, so your question comes in two parts. If it is possible to separate the two, in other words, can we say that he could have buried the back claim with the back doctors who weren't able to comment then on a knee, and so we have a new slate, a clean slate, like a magic slate? Assuming that's even possible, the claimant made representations of to his ability to walk, and toward the end, his knee and his leg became interchangeable as the reasons why he was unemployable and couldn't walk. And it's just impossible, like I said in the brief, to separate the two halves of that glass of water. Those
And the
complaints-
timing there works out so that that statement, in your view, would cover both the knee and the back.
Yes, and he said he made the misrepresentations to doctors. They said these were marked. They said he was talking about pain at a level of 10 plus. In other words, the most extreme pain imaginable doesn't come close to describing his circumstances. It's far beyond the most extreme pain imaginable. On a day where the doctor says, I would have expected a 100% recovery, but to give him the benefit of the doubt, I gave him another and then another costly test because the doctors would rather go their entire practice and not have a case like this, but when they have, they are exceedingly polite very often, so they test after test, so claimant got his bone scanned, and then he's still dismissed with a 0% impairment. This is a claimant who says, I can never work again, and I'm an invalid, and I bought myself a scooter to prove it. So those representations in this comp claim foreclose the conclusion here. The lifting of the bicycle makes it ironclad irrefutable. The judge virtually tells us so in the rehearing when he uses the very illuminating word material. He says, I find there's no material misrepresentation, page 602 in the record. Well, we've repudiated that in McHale versus Village North Palm Beach. There's a recent case, Liggett versus Barnett, I cite in the reply brief because it came out in the period between the briefs, where the claimant said, well, okay, but how about the period before I lied? Can I get those benefits, please? No, go home. Sorry. The Wright versus Uniforms for Industry sets the standard that any misrepresentation, I even use a Garden of Eden metaphor in my brief, equals forfeiture of all benefits. So those benefits are forfeited. So the judge doesn't get to say material because I looked into his eyes and I believed him when he sincerely said he lifted carefully. After saying his wife lifted, well, okay, but he went home and he did some science experiments and he weighed those bikes. And they actually came within some of it. Forget all that. I'm sorry. It's simply that he has cast in stone his misrepresentation. And the clearest one is the bikes, because there's no way out of that one. That's why I center on it. His deposition was a travesty. To go through the process that the defense attorney had to go through.
You're getting in seriously into your rebuttal and your reply to the cross appeal time.
Thank you very much. I will be back for what time is given me. Thank you.
Thank you. I will give you an extra minute and a half, and both sides.
Good afternoon. I'm Wendy LaQuasto of Fox & LaQuasto. I'm here today representing appellee cross-appellant James Arnold, who was a claimant in the proceeding below. As I said earlier, I'm reserving 3 minutes for rebuttal on my cross-appeal, although we've talked a lot about the cross-appeal already, so I'm not sure how that'll work out. I think that it's really important to note here on the first issue that what we have going on here is an employer carrier making a better, stronger misrepresentation case in this appeal than was made below. This is an error correcting court. Your focus is on what the JCC had to determine. And this misrepresentation was just as to physical abilities and post-injury earnings. That's the only thing that was ever said all the way up through pretrial. It is not until the trial memo is filed by the employer carrier 2 days before the hearing that we actually have any indication of what these misrepresentations actually are. And there he says, Dr. Solomon looked at the video and he said, well, he's lifting a bike, he's driving, and he's walking without assistance. Dr. Pagano looked at the video and said he's walking without assistance. And then there's also the scrap metal receipts that were filed on the 28th. I think that's January 28th, the hearing's February 4th, so less than a week before. So those are that's when claimant has knowledge about what the misrepresentations are. So as you've indicated, Judge Osterhaus, this is a real due process issue. It's okay for a claimant to have to scramble to be able to put together a case at trial to be able to refute these things, but it's not okay for that specificity objection to come up at that time.
I guess the difficulty is, though, that your side was on notice of this months earlier, and so here we are 2 days before trial, and this all comes to a head.
Yeah.
And the rule gives them 10 days to fix it.
Right, the timing's not great, and I understand that, but there's never any indication about anything more than physical abilities and post-injury earnings until that's when it's set as in pre-trial in December, okay? So in a perfect world, maybe there would have been something said then, but there wasn't. But as to this inability to do anything, 2 days before the trial, an objection is made, or is at least he's aware of that objection 2 days before when the trial memo comes in, and the employer carrier does nothing. Does no attempt to flesh it out. Of course, you could say they fleshed it out in their trial memo. Maybe that's when they fleshed it out. And I think
Do you feel like it's been fleshed out now? Do you know what the statements are that they're alleging?
Well, I've put together that's kind of an unfair question now because I've tried to come up with answers to these things for my oral argument. So ideally, I think that there should be much more specificity as to what's done here. I have gone through this and to my best of my ability from reading the trial memo and the arguments that were made, I'm seeing that the employer care is saying he misrepresented that he said he didn't lift any bikes. He misrepresented that he could never walk without an assisted device, and he misrepresented that he drove, and he misrepresented his earnings by not reporting them. Well, I'm going to point you to he got to respond to those things at trial, and he did. And the JCC accepted those explanations. He said in paragraph 14, the JCC explains about the surveillance film. He says it's a relatively short film. He says he's walking unrestricted, albeit slowly. And he's not using a cane, but he's moving slowly. He's shown standing on his tiptoes, and he lifts the spike up by lifting the front wheel, then the back wheel. Well, this is exactly what claimant said at trial. He said, I lowered the tailgate, I lifted the front wheel, I then lifted and then pushed it up with the back wheel. I weighed a similar bike, and it only weighs 7 pounds when you lift it that way, each part of it. The JCC accepted that testimony, found that testimony to be credible. Claimant testified, I can walk 50 or 100 yards unassisted. He said that. He never said, I can't ever walk without my scooter or my walker or my cane or holding on to my wife. He never said that. I can't ever do it. In fact, he testified at one point, I do some stuff and then I pay for it with pain later, And he also said, that he does, he tries not to drive when he takes his medication, but there's been times when he does it. So what we're doing here is taking a video and saying, this video, what's depicted on this video is what claimant is capable of doing every day, all the time. And as his trial counsel pointed out, this is just a small little piece, as the JCC relatively short video that shows a little space of time on 2 days. Were those good days or bad days? Claimant testified, I have good days and bad days. He said that. And, this all boils down to a retrial of the credibility of claimant. And the JCC looked at that video, listened to claimant's testimony, listened to his explanation, and said, this is not misrepresentation.
As to the knee, is the fact that the JCC limited its look at the misrepresentation specifically to the knee instead of to the petition for benefits more broadly a problem?
I think that that's cleared up in rehearing. And this exact argument about the bifurcation, this is not a bifurcation, and this is not, but this same argument, oh, you're restricting the misrepresentation only to the knee, and he points to these passages in the final order. That's all in the motion for rehearing. It's all in motion, and it's argued at the hearing. And the JCC, confronted with that, says, well, you know, I could have said, I looked at all this, I looked at the video, I examined credibility, I listened to what claimants said, I looked at all these doctor reports, and there's no misrepresentation. I could have said that in the final order. I just wrote it the way you did because that's the way it was stipulated. You stipulated that we're only here on a knee. So that's the way I wrote it. But, you know, that's what I wrote in my argument. If there was some sort of misstatement by the judge about limiting this to only the knee or, you know, then I submit that that's harmless error based upon his oral pronouncement at his hearing. I could have said that. I could have said no misrepresentation. That's in my brief. It's towards the end of my issue 1 argument. So I think that that's, and the same is true of the misrepresentation as to the scrapping earnings. You know, claimant testified at the trial. I didn't know where to put these on the forms. I called the adjuster. I told her what I had done. Where do I put this on the forms? And she said, "This is a one-time thing. You're cleaning up your house." And he said, yeah, I'm cleaning up my house, and that's exactly what he was doing. His home insurance was not going to cover his house anymore because he had so much stuff there. And he testified, he had plans after his retirement that he was going to have a little business at his home. He was going to fix and repair and sell lawnmowers. That's what he was going to do. That's why he had so much stuff there. And after he's injured, he realizes he can't do that anymore, so he scraps it. But there's absolutely no testimony that he lifted or loaded or did any of that. And he testified, I talked to her, she told me I didn't have to report it. So the fact that he didn't report it is not a misrepresentation. The JCC accepted that explanation, and that's CSE to support the finding that there's no misrepresentation. The last thing that, the EC puts a lot of faith in the fact that at the deposition, Mr. Arnold was directly asked, have you lifted any bikes into your truck? And he said no. And at trial, he explained that. He said, I don't remember being asked that question. Obviously, it's wrong when you look at the video. Let me explain what I did. And the JCC accepted that. You can't... Misrepresentation is, as I pointed out in my brief, it's a factual finding. It's based on what the JCC decides. You all might decide something else, but it's what the JCC decided, and if there's CSE to support it, then it gets to be, then it has to be affirmed, and that's exactly what happened here.
But you're saying that the JCC found that there was not misrepresentation, not that there was misrepresentation, but it was not material, correct?
Could you repeat that, please?
You're arguing that the JCC found that was not misrepresentation, not that the JCC found misrepresentation, but said it was not material or it was unimportant.
Correct.
Okay.
Correct. And once again, all this goes back to the lack of specificity of what am I supposed to be defending against, and what was he supposed to be defending against. On the second issue on PTD, we haven't talked a lot about that, but I just want to say, the EC asserted that the JCC applied their incorrect test. No, the JCC properly cited Toscano for the correct test. Claimant satisfied that because he's not an MMI by Dr. Alexander. He has restrictions which his unrefuted testimony preclude him from doing his prior employment. He's earned little or nothing since then. So that satisfies it, and the EC did nothing to prove its defenses. I explained that on my briefs, and so rely on the argument there. On the cross appeal, it's a lack of specificity. I've laid that out in the brief. The rule came into effect in November, which is after this was first asserted. Misrepresentation was first asserted in July, just misrepresentation. And then this new rule came into effect in November, and nothing was done. The pretrial was entered, and there's only the physical abilities earning that's in there. And there wasn't this case out of the first DCA about the specificity until December. So it's a new law thing. I'm sure it caught everybody kind of off guard. But once brought to the JCC's attention, I think the JCC had to look at that, and he did. He found that it was specific enough. I maintain that it's not specific enough. I mean, if you were going to have to defend against misrepresentation, I think you'd want to know where in the deposition or what it was in the deposition you said specifically so that you could respond to it. This is misrepresentation is a big defense, and it eliminates any benefits from a person who's legitimately injured. Now, I understand they make a misrepresentation, but there's no question here that this man was legitimately injured. These are compensable injuries, and the EC agreed. I think that this is important for you to understand. The EC agreed at the hearing that if misrepresentation was determined contrary to their position, that they would provide, I was wanting to see if I was counting up or counting down, that they would provide not only the knee, the requested knee, but also further treatment for the back, pain management. They would find a new pain management doctor because Solomon had retired. And so they said that. That's why this is not a voluntary dismissal of I'm not ready to go to trial on the back issues. This is an agreement that if misrepresentation is resolved in claimant's favor, the EC is going to provide the medical. So it's not some manipulation by the claimant to withdraw a petition at the last minute to somehow bifurcate the issues. That's not what's going on. This is an EC who's agreed to pay the medical if it fails on misrepresentation. And I submit that the JCC made factual findings that are supported by CSE to support the finding that there is no misrepresentation here. That the things that the JCC was called upon to decide, those limited things that we can glean from the trial memo and the arguments made at trial, he looked at those things, he decided they were not misrepresentations, and there's CSE to support that. I'm not hearing any more questions. I'm looking at my papers, and I don't really think I'll say anything else, so I'll reserve the rest of my time. Thank you. I will simply ask you to affirm on the direct appeal, and if you have to reach the cross appeal, to reverse.
The claimant obviously knew what was up for trial, having weighed his bicycles and having come up with a weight that one of the defense witnesses, or what common sense would dictate, is a weight of a bike, 15 pounds, which are the Olympic category bikes in the multi-thousands of dollars, not likely found at yard sales. The point is, he does weighing experiments at home in his pretrial preparation. He knows what's up. Everything they had explained was explained because they knew what was up. The representations to 50 and 100 are to feet, not yards, and I believe you'll find very many of those, a few of those record sites include or at all, without his wife, scooter, etc. Now, the idea that the clean up the house exculpates the dozens of tons of scrap that was brought in is why we spent the time on page 9, 10, 11 of our initial brief articulating what was found in those scrap receipts. 53 pounds of insulated wire, tons of iron, and then he covers by saying, well, there were some neighbors' goods too. So remember, the adjuster was asked, is this a one-time thing cleaning up your arm? And there were 11 trips. He was making it sound as though it was one trip. The judge said one still photo. The evidence has 11 photos, each a different setting, day, at the Anacott scrap yards, where tons and tons of metal. So the claimant's on notice of even taking her argument at face value, physical abilities and earnings. That's everything that was covered in these misrepresentations. If clarification was needed, clarification should have been sought. That was what the pretrial said, your physical abilities and your earnings, and that's exactly what was put on in terms of the defense. Now, remember that the doctors said what they saw was not slow walking, but normal walking, unaffected. That was the only objective medical evidence in this case as to what was revealed in the surveillance films. Once again, the claimant says that once the judge enters the thing called fact-finding, it's immutable on appeal. That's not so. An ancient case of the Supreme Court, Maller versus Lauderdale Lakes National Bank, 1975 case, says some overt facts derive no added gloss from the trier of fact's superior vantage point. And that was a case that judged the claimant's work search, which is something I could say applies to our point 2 in the alternative, and that is dealing with the temporary benefits award, that the claimant's overt efforts to find work are not a fact which derive added gloss from the trier of fact's superior vantage point. That citation is 322 Southern 2nd, 507. So this is the word material becomes important in rehearing, just as you saw in the McHale case. Well, what does where my car is parked have to do with how far I can bend or not bend? And this court said in McHale versus Village of North Palm Beach, which I'm familiar with, that it does not matter exactly what the thing is that you're misrepresenting so long as it impacts your case in your mind when you're saying it. And so the fact that these are not protected utterances from appellate scrutiny. They are objective facts. I did not lift those bikes. No, sir. My wife lifted them. The sellers lifted them, mainly the sellers, but my wife helped, but not me. No, 2 weeks ago we're talking about. That's a misrepresentation. He admitted it on the record. The claimant admits it on the brief. This is not a fact that derives any added gloss from the trier of fact's vantage point. Not looking at the depot, but hearing the claimant after he does his bike weighing experiments and said how carefully he actually did lift them. So we do not have a forgiveness policy if you can't remember the deceptive or misleading comment. And again, the deposition, my point that I was at in my direct was, if you follow the process of this deposition, it's a horrifying cat and mouse game where he says, well, I don't even want to speculate on what my earnings were post-accident. And the attorney says, well, I object, but you can go ahead and answer. He says, well, I choose not to. The defense attorney understood he didn't need to accept that answer. And every time claimant was pressed, there became more and more. I just carry out some towels that we're going to donate to the Humane Society. Okay, tons of scrap, whatever. Just a couple of knickknacks that my wife likes from now and then. Well, we actually go to yard sales every single weekend of the year, every single Saturday, and most Fridays, or at least occasional Fridays, but every single one on a predetermined, scientific map. This is not the sort of claim who buys his props and comes to the workers' comp court and gets zeros from the treating physicians for at least the back segment, who say they find nothing wrong. And he is saying from day one, I can't work and I never will, to anybody who will listen. It's not somebody worthy of our system's help. And I can't picture actually a much clearer case than this one in terms of both the misrepresentations and the other issues that we have before us. So it seems to me that the point on the cross appeal is highly moot in light of the many points I've already raised. And without repeating, I think the fact that even as it lay...
Mr. Kagan, I'm going to have to ask you to wrap it up, please.
And I respectfully request this honorable court reverse, because everything that is needed to reverse is present in the record already.
Thank you.
Thank you, Your Honor.
I think the only thing Mr. Kagan said about the cross appeal was that it was moot, and that may be if you affirm as to issues 1 and 2, I'm not sure that it makes it moot, but it makes it unnecessary for you to reach it. But I think that this is an issue that the bench and bar could use some help with. So once again, I ask you to affirm on the direct appeal, and if you find that you have to reach the cross appeal, to reverse. Thank you.
Thank you, Ms. LaQuesta. In that we have no other cases, we are adjourned.
All rise.